Hi, good afternoon, everyone. This is Andrea Chambers. I'm a partner at DLA Piper in the Energy Finance Group. I'm also the president of the Northeast chapter. Let me try it without the mic because I think I'm getting echoed here. Can you hear me? Maybe not.
I think they can. I think they're just muted.
Okay. Can you hear me?
Okay.
Okay. All right. So I would like to also introduce Theodore Paradise. He's the vice president of the Northeast chapter, and we welcome everyone to today's presentation on offshore wind developments in the Northeast. And I'll turn it over to Theodore.
All right. Good afternoon, everybody. Thank you for joining us for this panel discussion this November Friday afternoon. And thanks for everybody who made it in person with the weather. That was a little harder than I think we all anticipated it was going to be. So this is a timely panel for folks who were in DC for the mid-year EBA meeting. There was lots of discussion on the changing resource mix on the grid, jurisdiction issues, interconnection issues, siting issues. All these things were coming up in some of those discussions, and I think it's just a sign of the times that we're living in. We've gone from a space where people would talk about offshore wind with maybe a bit of an eye roll because they were thinking of, maybe Cape Wind and all of the challenges there, and it hadn't gone really well. But things have really, I think, turned a corner, and all of a sudden we have Block Island Wind there, and the notion of offshore wind is very real. And states are pursuing that vigorously. So today's panel, I think, is timely. We have a great set of speakers, and I'll just introduce them very quickly. I'm not going to read everybody's full bio. That's in the materials. Scott Mahoney is Senior Vice President, General Counsel, Chief Compliance Officer at Avangrid. And Scott is going to be doing his presentation from Maine as a direct result of the winter storm yesterday. I was able to make it down from Massachusetts, but Maine is a different issue altogether. So Scott's going to be joining us by phone, and we're delighted to have him. And then we have Noah Shaw, who's General Counsel and Secretary for NYPA, or NYSERDA, sorry. And pleased to have you with us today, Noah. Joshua Kaplowitz, did I get his name right, Andrea? Joshua is with the U.S. Department of Interior, branch of offshore resources, and he has a lot to share with us about the permitting process in federal waters. Charles Scott is Senior Legal Counsel at Orsted North America, and he's going to help give us insight into the developer perspective on things as issues in offshore wind really heat up. So with that, we are going to start today's... I
guess I'll just introduce myself.
Oh, and I'm sorry. And Amber Martin, who is a staff attorney, and I apologize, Amber, I was going through my list here and I scrolled too fast with the Connecticut PURA, the state regulator in Connecticut, and we're delighted to have you, Amber, and I apologize. I'm not a professional moderator, so... You'll have to give me a slight pass on that. So with that, I think we can dive right into the program. If you have questions, email Andrea Chambers with those, and she can read those out at the end of the program for folks. So we'll start with Scott Mahoney of Avangrid, and Scott, we can do your slide advancement from here.
All right, great. Thank you, and good afternoon, everyone. I was in New Haven yesterday, but then I had to come up to Maine last night and and couldn't get out either last night or this morning, so I apologize that I can't be there with the other panelists. I'm going to provide an overview of Avangrid and Vineyard Wind, and in particular sort of note what we're seeing as the different work streams that are required to get a big project like this going. I know that some of our other panelists will get into a lot more detail on some of the things that I'm just sort of flagging as things that we're working on, and I think it'll lead for some good discussion at the end. So Avangrid is a NYSE public company where Iberdrola SA has a controlling interest. And we have two lines of business. We have the utilities under networks, and we have the renewables business. Next slide. Next slide, Andrea. So Avangrid was formed in 2015 with a merger of Iberdrola USA and UIL, and then we changed our name to Avangrid, and we're really taking a leading position as a sustainable U.S. Energy company. Next slide. So you can see our footprint. Our utilities are located in the Northeast, in Maine, Connecticut, New York, and Massachusetts, and our renewable business is located across the country, with our headquarters in Orange, Connecticut. Next slide. So Avangrid, like Iberdrola, which is the world's largest renewables company, is a leader in sustainability in terms of both our networks business and obviously our renewables business. And we've really made a strong commitment that for that business strategy. So next slide. In addition, we've made good governance a foundation for the preservation and the growth of value at the company, and are doing all that we can to stay in the forefront on that. So then with respect to our renewables business, for an overview, next slide. So we have a huge pipeline of projects, and currently we have 6 projects under active construction, as you can see, in the Midwest, Oregon, and Texas. And that's in addition to the Vineyard Wind. So next slide. So then with respect to Vineyard Wind, the largest U.S. offshore project, the lease is 15 miles south of Martha's Vineyard in good water depth. It's a sizable lease area with the potential for up to 1,600 megawatts. And this year we were selected for a 20-year PPA of 800 megawatts by the Massachusetts electric distribution companies that's currently pending before the Mass BPU. The history for the Vineyard Wind project is it was acquired by CIP in 2016, and then Avangrid formed a joint venture by acquiring 50% of Vineyard Wind in 2017, and then, as I said, selection this year of the project for the Massachusetts 83C. So next slide. So there's some of the basics on the projects. Under the PPA with the Mass EDCs, it's structured in 2 phases, with the first phase of commercial operation in 2021 and the second phase in 2022. It was the first offshore farm to apply for the construction operation plan from BOEM, and the BOEM approval time frame allows for the ITC qualification beginning in 2021. So next slide. I think, Andrew, you skipped one slide. Oh, no, I'm sorry. I was out of sequence on my slides here. Excuse me. So slide 13. Okay. The project under the Massachusetts 83C, excuse me, it was 14, Andrea. I apologize. This is the problem with being remote. Your page numbers are different than mine. I'll pay attention. So for the Massachusetts solicitation, the criteria included enhanced reliability, reducing winter price spikes, cost effective for ratepayers, being able to demonstrate project viability, and where feasible to create and foster employment and economic development in Massachusetts. The required finding was a cost-effective mechanism for procuring low-cost renewable energy on a long-term basis. And I think when the pricing, was announced, it made quite a bit of news, given how competitive it was. So next slide, on to some of the legal work streams that we have. So perhaps most important in the work streams are the various approvals, agreements, and consultations. I tried to identify some of the agencies that we're working with for that, and this certainly doesn't cover them all. But you can see there's quite a complex set of government entities and stakeholders that we're interacting with in order to get this project up and running. Next slide. With respect to the kind of legal support that's required, it's really at, what we've found is it's at every stage of the project, from simple things like land and project acquisition, leases, good neighbor and community agreements, the resource assessment and permitting, so the interaction with the various state, federal, and local agencies, agreements with non-governmental organizations, interconnection agreements with the independent system operator and the local transmission companies, on the construction and engineering work, including such important things as the turbine supply, EPC and construction agreements, the relationship of project labor agreements to that work are all very important. Next slide. In addition, as the project matures, there's also legal support required for the operations and asset management, for issues related to origination and offtake, and potentially even in trading and trading compliance issues with respect to energy sales. We also, this is a joint venture with Copenhagen Infrastructure Partners, CIP. And so in addition to the ordinary corporate governance issues that you'd have on a project, here with a joint venture, you have, it requires particular attention to proper governance and decision making. Next slide. Next slide, Andrew.
Did you want updates? I have slide 20, or am I too?
I'm sorry. Then my WebEx is slow.
That's okay.
I'm sorry. Now it's on slide 20. Thank you.
Great.
So the Vineyard Wind project is currently on target with the timeline and expectations. If you go to slide 21, it shows some of the specific approvals where the applications have been filed and pending. And there is one mistake on this slide, I think as it went across the web. If you look in the last column to the right, the Mass DPU approval of contracts, that check mark that's in expected spring 19 should be down below in the Mass EPA and not in the DPUC. So the DPUC case has been filed and is now pending with the Mass DPUC, but hasn't been granted at this stage. So next slide. So in addition to Vineyard Wind, we view that there are additional opportunities. Next slide. So with respect to the lease area for Vineyard Wind, we see additional opportunities announced in Massachusetts, Connecticut, New York, and Rhode Island, as well as additional BOEM lease auctions in the area upcoming. Next slide. And then, sort of lastly, in addition to the Vineyard Wind project, Avangrid is the sole owner of the lease rights for Kitty Hawk, which is located off North Carolina and has a great potential for development. And that concludes my slides.
Thank you, Scott.
All right. So now we'll move to Noah Shaw from NYSERDA.
Thank you, Theodore. Thanks for everybody for being here today. Some of my slides, because I had to submit them a week ago and because things are moving so quickly, are already out of date. But, it's timely to be here to talk about the RFP that we just put out a little more than a week ago, and to talk not only about the sort of foundation for our RFP, but also, without turning this into a bidders conference, because we do have two potential bidders in the room. Just sort of going through some of the provisions in the RFP and in the form contract that we issued along with the RFP that are a little bit different and interesting, I think, to lawyers, just given the sort of unique structure of our program here in New York. Before I get started, and because there are bidders in the room and there is an RFP on the street, I just want to say that, when we get into the conversation part of this, please be careful to, I can answer questions with respect to sort of clarifying issues with respect to the RFP, but hopefully folks will stay away from any attempts to influence, if you will. And so, the lawyerly prefatory phrase that I hope everybody appreciates. So the foundation, which maybe is familiar to a lot of you, but may not be familiar to everybody, is New York State's Clean Energy Standard, order issued August 1st, 2016. We structured this as a REC for the renewable side of the Clean Energy Standard, structured as a REC-based compliance mechanism. NYSERDA issues RFPs. We provide awards to purchase RECs on a competitive basis. Those RECs are then registered in our generation attribute tracking system, and the load-serving entities in New York have a compliance obligation to purchase those RECs according to their proportional share of load. So that is the sort of basic regulatory structure on which our effort to reach 50% renewables by 2030 is built. And while the offshore wind order, which was issued in July of this past summer, which I'll get to in a minute, is a separate compliance mechanism, it takes a very similar sort of methodology for how to sort of run the program. Our goal in New York is 2,400 megawatts of offshore wind by 2030. That's the current goal. We see that as, frankly, quite doable and feeling more doable all the time as prices go down, as more wind energy areas are identified and hopefully leased soon, Josh. And we make our progress through the supply chain and processes. I don't know if any of you were there, but we held a suppliers forum here in town yesterday to talk about supply chain processes. There were 250 people in the room from all over the world. So there's a big pull, and there's a lot of planning going on in terms of how to build the infrastructure to meet these goals. 2,400 megawatts is obviously, feels like a lot for one state, but you've got a bunch of similar or even bigger goals around us. The market is probably a 10 gigawatt market right now. So prior to our RFP, NYSERDA led a state process to draft something called the New York State Offshore Wind Master Plan, which was a very comprehensive analysis with respect to not only the sort of legal procurement questions and how the resource will be paid for and how much it might cost and all of those things which lawyers like to talk about, but lots of things that environmental analysts like to talk about, and that other kinds of other folks within the project development ecosystem dig into. So it sort of, the major deliverable from the master plan, if you will, was a large package that we delivered to BOEM last fall, so October of, I can't believe that was a year ago, October of 2017, that made recommendations for additional wind energy areas to be leased that we felt were least conflicted but also lowest cost. And I think we've worked closely with BOEM over the course of that time, and just the other day they issued some draft call areas that that are within the sort of scope of the suggestions that we made a year ago. For the state, obviously, the economic benefits and jobs are a major part of this. Our analysis shows that even just at the 2,400 megawatt number, we're looking at likely 5,000 new jobs, good, well-paying, long-term jobs in installation, O&M, manufacturing. Those jobs, most people think they're only going to be, on Long Island or in the ports down here in the city, and a lot of them will be, but, some of these ports may be up the Hudson River. There's obviously a strong desire to encourage economic development here in the state to the extent that the state is paying for the projects. We understand the economic realities of keeping costs low also, and, as when we get into the RFP, I can talk a little bit about how we tried to strike that balance. This is a map of the current lease areas. I think after I looked at other folks' presentations, I think you may see that map a couple or three times today. It gives you an idea of, the situation of these areas vis-a-vis interconnecting into zones J or K downstate in New York. There's one that's close. There are some that are further away, and when I get into the RFP, we found it necessary to figure out a way to accept bids from projects that would interconnect in other control areas. So we will be accepting bids from projects that interconnect in PJM or the New England ISO, contingent upon the ability to show delivery of the electricity into the New York control area. So that got complicated, and there's a lot of fine print in the form contract if anybody wants to look at it. But hopefully, as more lease areas are added, our next solicitation will have even more bidders. There will be more that can interconnect directly, and as this all evolves and we look at transmission the pieces really start to fit together. I'm going to skip by this one because it's out of date as of like 2 days ago. Josh, I hope, is going to talk a little bit about what they issued the other day for additional call areas and the process moving forward on that front. New York State has been pushing very, very hard. I think probably harder than most states to have additional areas identified as soon as possible. We see competition as good. More areas means more bidders, means lower costs for ratepayers. So that is a very high priority for us as we move through this process. So just a couple notes with respect to the order for what we call Phase 1 of our offshore wind program. Excuse me. Phase 1 is, Phase 1 comes before Phase 2, I'll say that. Phase 1 is sort of cabined as an approximately 800 megawatt goal. We, depending upon value and viability and the other factors that are laid out in the RFP, we could award a little bit more than that. We could award a little less. We could award multiple projects. But it establishes that goal as a regulatory sort of matter. It describes an offshore wind renewable energy credit mechanism for the procurement of attributes, which is different, obviously, from our neighbors, which are doing this through PPAs and the utilities. NYSERDA is the quote-unquote procurement entity. We'll run these solicitations and auctions in a way similar to the way we do onshore wind, just with a different sort of structure of the REC, which I'll get into in a minute, and a different LSE obligation. So the compliance obligation for ORECs is outside the scope of the Clean Energy Standard order. So in other words, we didn't create a new tier within the Clean Energy Standard. These are different from what we call Tier 1 RECs in New York, which are sort of the more traditional land-based RECs. The compliance obligation is an additional compliance obligation on LSEs to purchase these RECs. Similar to as I said, similar to the Clean Energy Standard, but separate. And the order, for those of you who have had a chance to read it, it's actually, as far as orders go, it's relatively concise and pretty straightforward. And part of the reason that it's concise and straightforward is because it provided NYSERDA a lot of discretion with respect to how to frame the RFP, how to think about a wide range of mechanisms regarding the structure of the prices, how to calculate value with respect to this new thing of an index OREC that we came up with, how to think about labor provisions, how to structure the economic development factors, and all of that. And it identifies the other thing about the order, and I don't think anybody from Amberic is here, but it pushed the question of wet transmission from a procurement point of view to Phase 2. I think the decision was for Phase 1, the developers are going to bid that cost in the sort of traditional way. These will be radial interconnections, at least for Phase 1. For Phase 2, as more areas are identified, as this market develops, we'll start thinking about whether the state paying for costs related to an integrated transmission system makes sense, and how those risks may be allocated between the developers and the utilities, and all of those complicated issues that need to be taken up with respect to transmission at some point. But we were worried would really bog down the process for Phase 1, and we need to get to market. I don't know exactly how this slide got a little funky, but I think that the highlights are here with respect to our RFP. The scoring criteria were set in the order. So 70% for bid price, 20% for economic benefits, and 10% for project viability. These are a few of the contract requirements that are required in the order. Well, actually, the order authorized NYSERDA to consider the value of project labor agreement and prevailing wage. You'll see in the RFP that we do require prevailing wage, and we require the negotiation of a project labor agreement. We require the submission of a fisheries and environmental mitigation plan, that bidders participate in our technical working groups, consultation with various different state agencies regarding the different permits and different considerations that the project will have to be aware of. Publication of environmental data collected during the site assessment, lighting controls, minimizing visual impacts to the extent possible, all of that. And this is, I literally was writing this, I think the day we were issuing the RFP. So the intent to bid, I believe, is December 20th. Proposals are due February 14th. We expect to make awards in the spring, and hopefully, depending upon how difficult the awardee wants to be, execute contracts early summer. Obviously, there's a clock on the tax credits, and so there's a desire for most of these developers to have a contract in place soon. So that's sort of, I don't know, what's the tip of one of these blades on an 11 megawatt turbine? I think it's like 1,000 feet up in the air. So that's the 1,000-foot look. This is the on the ground look. I'm not going to get too. Basically, what I did here was, in order to avoid, editorializing, I just took some of the language from our contract and a few of the interesting provisions, and copied it in here, and hopefully it'll be sort of a jumping off point for a conversation. I think I mentioned a minute ago, and I don't have a slide in here in particular, about the two REC mechanisms that the order required us to required NYSERDA to require bidders to submit bids under. So one is sort of a traditional fixed REC methodology, where you bid a price. That's the price for the term of the 25-year contract for your RECs. Obviously, with an emerging technology like that, we understand there's a premium on that cost. We wanted to get to a REC structure that was more cost-effective, more hedgeable, if you will, but not run afoul of jurisdictional issues with the wholesale markets. The index OREC price structures the reference price using a blended average of prior months' prices cleared between zones J and K. So it's not the price that the generator clears. It's not a particular project's price at all. It's that blended average of those two zones. And we don't require any bidding into the NYSO wholesale market or any other wholesale market. If these projects wanted to sell bilaterally, they can do that. So there is no tethering to the wholesale markets. Nevertheless, as I think the Commission's own hedge, wanted to make sure we got two bids, so that to really sort of ensure the longevity and security of the program. So what we have here is a reversion. So let's say in the very unlikely scenario that there's a challenge to our index OREC structure, and the index OREC structure is no longer valid. This provision provides for the reversion to the fixed REC price. It's hopefully pretty straightforward. We thought simplicity was better than complexity in this regard. We understand that this is a 25-year contract. Lots of things can happen over the course of the 25 years. So it provides for a reversion, but then also sort of a snapback, as things evolve. This next provision, which is, I think, unique to New York, is the eligibility of projects that interconnect outside of the New York control area. So I was just actually talking with Theodore. In our land-based procurements, we have always provided for projects to bid in outside of New York State. The only control area where they've ever come from was PJM. I don't think we've actually made any awards, but we've had applications. And the requirement in PJM is to show a sort of quote unquote contract path in order to sort of demonstrate firm delivery of the electricity into New York, so that the RECs can be created in our generation attribute tracking system. Right. The whole idea here is that the energy that we're paying for is consumed in New York. If we're not showing that, then we're not living up to the Commission's orders for our clean energy standard and offshore wind order. However, we need, in order to drive costs down and in order to increase the number of bidders, we need to be able to maximize the number of projects that can bid in. So PJM allows the firm delivery showing using a contract path. The New England ISO is a little different. Had a bunch of conversations with the New England ISO. What we landed on was basically a NERC tag with notes that indicate the source of the generation. It's a little bit, there are more weeds there, but they're probably not worth going into right now. If you want to check the provisions of the contract or ask any questions about that, afterwards, I'll be happy to try to answer them, or I may refer you to my staff attorney, who was really boots on the ground in those conversations with the New England ISO. The next provision I wanted to talk about was what we call a change of law provision regarding wholesale market uncertainties. In other words, there is a variable in the bid structure that allows folks to basically quantify what they expect to be able to clear in the capacity markets over the course of the term of the contract. Now, as everybody here probably knows, I don't know what the hell is going to happen with the capacity markets. We don't have capacity markets in 5-10 years, and there's certainly a more than minimal likelihood that offshore wind will end up being mitigated, or there will be some other rule that pops out of FERC that makes it basically difficult or impossible for offshore wind resources to clear in their capacity in the NYSO capacity markets, or maybe some other capacity markets. So we wanted to provide for the possibility of that. This was a difficult provision to draft. I expect that folks will have feelings about this when we start the negotiation, but it's basically meant, it's something like an opener, but it's meant to allow for the accommodation of a material change in the project's expected revenue through capacity markets that may come about during the tenor of the contract. Just a quick note on the PLA and prevailing wage requirements. Again, this was obviously a balancing act. Prevailing wage, I think, is relatively straightforward. These are not public works, under labor law here in New York. I mean, they're not New York State projects. We pay for RECs. These are not construction projects. Nevertheless, as a matter of policy, and after a good bit of analysis regarding cost effectiveness and the feasibility of these project labor agreements, decided that it was good policy to require that the developers, after the COP is approved, engage in a negotiation with the appropriate trades to reach a PLA, the elements of which are sort of laid out in our RFP. It's a little different than a normal project labor agreement because we don't know what the project's going to look like. Usually, when there's a bridge being built or something, you attach the required PLA to the RFP because you know exactly what the project's going to be. Here, it's a slightly more complex sort of indirect relationship to the requirement. Hold on just a minute. Let me just get through. I think we'll have plenty of time for questions at the end. So it's not an event of default if it's not reached. However, we do retain the discretion to require certain elements of what the project labor agreement would have contained if the parties can't reach an agreement. And we also retain the ability to require that the negotiations continue for an extended period of time and appoint mediators and other ways to sort of try to make sure that the folks come to the table in an appropriate way. I'm going to skip through that. Phase 2. So what happens after phase 1? So phase 2, assuming we contract 800 megawatts or something close to that, this in phase 1 in this first solicitation, I would expect the phase 2 process, which basically means phase 2 of the proceeding before the commission, will commence sometime next year. There will be, I'm sure, lots of lessons learned from our first run at this. There may be adjustments to the goal. I think it's committed that we're going to take up wet transmission in that proceeding. And, I have no doubt that as we make our way through this, developers, transmission owners, customers, utilities, other folks will have suggestions for how this process can be improved. So that's all I got. There was one question. Do we want to do that now, or do you want to wait?
Let's park that for now. We'll come back to it at the end. Just make a note mentally about the slide number too, if that helps. But yeah, we should have time for questions. So we're going to move to Amber Martin, who's an attorney with the Connecticut Public Utilities Regulatory Authority. Noah mentioned some things about tethering and mitigation in markets and other things that I think Amber's going to talk a little bit more about as the states see some emerging legal issues that's interesting around wind development. Amber.
Sure. Thank you, Theodore. And just before I jump in, I wanted to just read this disclaimer here. This presentation is for informational and discussion purposes only and does not establish final policy of the Connecticut Public Utilities Regulatory Authority or otherwise reflect the views of PURA or its individual commissioners. And all opinions expressed here today would be my own. And before I jump in as well, I just wanted to sort of give a roadmap of where we're going. My presentation is really focused on three things. Connecticut's policies shaping the state's energy mix, the tools in our toolbox to achieve those policies, and the impact of recent legal developments. So just as a spoiler alert, it's becoming very clear that states have solid authority to procure their preferred resources. So with that, I will jump in. So I just wanted to start by providing a quick overview of Connecticut's policies in this space. So Connecticut first passed its Global Warming Solutions Act in 1998. The act establishes targets for emissions reductions within the state, and these targets were recently amended by Connecticut Public Act 1882. So the targets are, or would require Connecticut to reduce greenhouse gas emissions to a level at least 10% below 1990 levels by January 1st, 2020, at least 45% below 2001 levels by January 1st, 2030, and at least 80% below 2001 levels by January 1st, 2050. In addition to the Global Warming Solutions Act targets, Connecticut also has set aggressive renewable portfolio standard targets. So the year-by-year requirements are set out here on this slide. But I did want to just touch very quickly on the first and the final targets provided here. By 2020, Connecticut's RPS requires at least 25% of the state's retail load to be served by either Class 1 or Class 2 resources. And so the way that division breaks down, most of this has to be met by Class 1 resources, but a smaller chunk, as you can see here on the slide, can be met by Class 2 resources. And then the final target laid out here, so sort of the end of the road for now, is that by 2030, Connecticut ramps up the requirement to require that at least 44% of the state's retail load is met by renewable resources. On this next slide, I've just laid out here the definition of Class 1 and Class 2 resources. So as you can see, Class 1 is fairly broad and includes your solar, wind, hydro, and biomass facilities, among other things, whereas Class 2 is more narrow and is limited to certain trash-to-energy facilities. To achieve these policies, Connecticut has pretty expansive procurement authority. And to provide some background for those of you who are not familiar, the way these procurements work is that the Department of Energy and Environmental Protection will develop and run requests for proposals for the desired types of resources and will select the winning bidders of those RFPs. Once the bidders are selected, the state's electric distribution companies will negotiate with the winning bidders the terms of power purchase agreements. Those power purchase agreements are then filed with PURA for review and approval. And the standard of review depends on the specific language in the statute usually, but typically is focused primarily on whether approving the contracts is in the best interest of ratepayers. So of this sort of toolkit here, most relevant to this discussion is the Connecticut General Statute Section 16A3H, which allows the state to procure up to 3% of its retail load from offshore wind. As noted on the slide, winning bidders were recently chosen and PPAs were filed with PURA. As a result, I'm limited in what I can say due to the authority's ex parte policy and the Uniform Administrative Procedure Act. So I'll just say sort of the overview of the public information. Connecticut selected in this RFP 200 megawatts of offshore wind from Revolution Wind. The New Englander in me always wants to pronounce that as Revolutionary Wind, which will be developed off the coast of Rhode Island and which is equal to the 3% of retail load allowable by statute. So PURA will issue a decision on those contracts. There's also a couple, I believe, fuel cell resources that were selected under the same RFP. PURA will issue a decision on those contracts by the end of the year as required by the statutory deadline. And I've listed the other procurement statutes here as well. So if you're curious about what else Connecticut can procure, I encourage you to take a look at those. The bottom line, though, is that Connecticut has authority to procure up to 68.6% of its retail load from renewable and zero carbon resources. And just to put sort of Connecticut's recent procurement in context, and something that Scott talked about a little bit, other procurements in New England include Massachusetts' selection of 800 megawatts of offshore wind from Vineyard Wind, which, as Scott noted, is pending before the Massachusetts DPU in docket number 1876. And Rhode Island recently selected 400 megawatts of offshore wind, also from Revolution Wind. So I believe the total output of Revolution Wind is 600 megawatts. So between Connecticut and Rhode Island, we've sort of monopolized all of that output. So having laid that foundation, I just wanted to step through some of the challenges that Connecticut has experienced, as well as other states, in offshore wind and renewables development. So the first set of challenges obviously deals with litigation risk. So I've outlined sort of a set of cases here that I think are most relevant to state contracting and procurement of renewables by states. So the first listed here is Hughes v. Talon Energy Marketing. I'm sure everyone is pretty familiar with this case, but just to recap briefly, in that case, the Supreme Court struck down state-sponsored contracts for differences intended to subsidize the development of new gas power plants in Maryland. The Supreme Court held that the Maryland program was preempted because it intruded on the Federal Energy Regulatory Commission's exclusive jurisdiction over the rates for wholesale sales of electricity. The fatal defect, according to the Supreme Court, was the conditioning of payment of funds under the program on the capacity from the selected power plants clearing in the PJM capacity auction. The court expressly noted, however, that nothing in its opinion should be read to foreclose Maryland and other states from encouraging production of new or clean generation through measures not tied to a generator's wholesale market participation. So turning to the ALCO case, and for those of you that are familiar with the ALCO cases, there's actually several iterations. This has been litigated up and down the courts several different times, but I'm talking specifically here today about the 2017 Second Circuit opinion, which upheld against preemption challenges similar to Hughes, claiming that the Connecticut procurements were preempted under the Federal Power Act. The Second Circuit, however, found that these programs were well within a state's traditional power to regulate their utilities, and any impact on the wholesale market associated with those procurements was purely incidental and did not impermissibly infringe on FERC's jurisdiction. The court also upheld in the same case Connecticut's Renewable Portfolio Standard Program against a Dormant Commerce Clause challenge. So the litigant in that case challenged the RPS, claiming that the restriction on what generators were eligible to produce RECs that required those generators to be able to deliver their power into New England was preempted or conflicted with the Dormant Commerce Clause. But the court said that this restriction in the REC program, or the RPS program, simply piggybacked on FERC-approved jurisdictional lines, and any impact on the interstate commerce was not enough to outweigh the interest of the state in ensuring that this power actually serves New England ratepayers. And finally, and most recently, the Second and Seventh Circuit recently upheld against preemption and Dormant Commerce Clause challenges state programs in New York and Illinois that provided zero emissions credits to nuclear units in order to compensate those generators for their environmental attributes. So to recap, in Hughes, sort of the significance of these cases. In Hughes, the court says that states can incentivize renewables, but not in a way tied to wholesale market participation. And in ALCO and the ZEC cases listed here, the courts make clear that states can define desirable characteristics of generation and compensate generators for those attributes, and that any incidental impact on the wholesale markets is permissible. So the upshot of these several cases is that they establish a solid foundation for states to go out and procure renewables, including offshore wind. But despite being backed by solid authority, these procurements face another set of challenges when it comes to how the selected resources participate in the wholesale electric market. So Hughes tells us states can't condition their programs on wholesale market participation. As a result, these projects have challenges when they try to participate in these markets. Particularly in the Northeast, state-sponsored resources face challenges with respect to participation in the capacity markets, and that's because ISO New England and PJM operate under what could be described as a mandatory capacity market. And what I mean by that is not that the resources are required to participate in the capacity market necessarily, but that in order to be counted toward the region's capacity requirements and to offset any sort of requirement of the load-serving entities in that region to purchase a specific amount of capacity, the resources must have cleared in the RTO-administered capacity market. In both New England and PJM, this is complicated by what's called the minimum offer price rule, which Noah referenced, and which sets a price floor under which bids coming in under the floor will be evaluated for competitiveness and often mitigated upward either to the floor price established by the MOPR or the resource's full cost. State-sponsored resources, however, typically would want to bid at less than their all-in cost because they want to ensure that they obtain the capacity revenues And the states that sponsored them have an interest in this too, to ensure that their ratepayers are not paying duplicative charges for capacity. So that is once for the sponsored resources, and a second time for resources that are cleared through the capacity auction that the RTO runs. The MOPR, however, constrains these resources' ability to bid by less than their costs. So on this slide and the next, I've listed some of the ways that FERC has dealt with this market friction between state-sponsored resources and how these capacity markets are designed, including in New England through a limited exemption for a portion of these resources. That exemption, though, is currently in the process of being phased out and replaced with the Competitive Markets and State-Sponsored Policy Resources, or CASPR design, which applies the MOPR to these resources but establishes sort of a second chance auction through which policy resources can seek to take on an existing generator's obligation, and that existing generator can retire. This provides less certainty than an exemption, but does attempt to accommodate entry of new sponsored resources. And then on this last slide, I've listed the recent PJM capacity market order in which FERC found that out-of-market subsidies were significantly impacting the efficacy of PJM's capacity market. And so this seems to extend the MOPR policy to include resources covered by renewable portfolio standards. And it's not clear that that was included before. In the same order, though, FERC also proposes a solution, and the sort of merits or alternatives to that are being worked out currently in litigation. So one of the ways that Connecticut deals and has dealt with this is that DEEP in its RFP encourages but does not require winning bidders to participate in the capacity market. I think the key takeaway here, though, is that despite the challenges, state-sponsored procurements and subsidies are continuing to grow and now have an even more certain legal foundation. And then just as a final note, this isn't really my wheelhouse, but I did want to mention it. There can be additional challenges in siting and transmission build-out. So I'm sure everyone knows Cape Wind. So I think after about a decade of litigation, they terminated their lease with the Bureau of Ocean Energy Management. And so that project will no longer go forward, but I think it's probably one of the most well-known. But, and I think Theodore mentioned this earlier, the climate does seem to be changing. So, you know, as he mentioned, we have Block Island Wind, which is commercially operational. We have Vineyard Wind, which is in development, and Revolution Wind also on the horizon. Additional challenges associated with this is that as more projects are developed, finding onshore landing points for transmission interconnection may become difficult or expensive. So right now what we're doing is we're typically piggybacking on older generators' retirements. So there's already a substation there for your radial tie line to connect to. But as those landing points are utilized, it could become more expensive where you have to build a substation to interconnect to the continental part of the New England grid. And additionally, the further that projects are developed offshore, so Vineyard Wind is obviously in federal waters, and that's becoming a more fruitful place to develop. Setting of transmission needed to connect offshore wind to the grid gets more complicated just in terms of expense and, you know, the other permits that you need and other things. So I think we're going to hold questions till the end. So with that, I will turn it over to Josh.
All right. So thanks, Amber, for that. So now we're going to transition again from the New York conference room here to DC. Where Josh Kaplowitz from the U.S. Department of Interior is joining us to talk about some of those issues that Amber closed with in terms of the development of wind farms in federal waters. Scott teed it up earlier with Vineyard Wind. We have our first wind farm being developed out a little farther from the coast. So a lot of new issues for the United States that we're going through for the first time. I think this will be interesting to hear from Josh, the perspective from the federal folks administering those rules. So Josh, you are up.
Mike's not on.
And we can't hear DC if DC's muted.
We're also looking at ourselves there.
Yes. And we look good.
I look good in a very small picture.
Well, that might be the myopia.
Did they hear us?
Just make sure, DC, can you hear us? And if so, can you turn the microphones on? I'd like to make it clear that no member of the Energy Bar Association is in charge of the technical aspects of offshore wind, so that's probably good news.
Big guns.
Do Josh first.
It is. All right, I think what we're going to do is we're going to, if this works, well, let me see, 1 second.
They're working on it.
Okay. Should we have Charles go?
Yes, that
Okay.
sounds good.
Charles, are you set to do that? We can advance the slides and then back them back up. Okay. So I didn't do Charles' introduction. Charles is Senior Legal Counsel for Ørsted North America. So Ørsted is the new name of Dutch Oil and Natural Gas, right? The big company in Europe with a lot of offshore wind development experience.
Yeah, I can
Go into all that.
give
That's
the
fantastic.
obligatory initial pitch for Ørsted. Ørsted is the worldwide leader in offshore wind. We have 24 wind farms in operation around the world, I think exclusively in Northern Europe at this point, totaling 5.1 gigawatts of capacity. That includes the current largest offshore wind farm in the world, which is the Walney extension at 650 megawatts, and we have under construction the even larger Hornsey project, which is going to be 1.2 gigawatt wind farm. Here in the United States, this slide unfortunately is also quite out of date because it only shows our two assets or three active projects that we had prior to last Wednesday. Last Wednesday, Ørsted closed on the acquisition of Deepwater Wind, a Rhode Island-based offshore wind developer that has one project in operation, the 30-megawatt Block Island Wind Farm, also has a current pipeline of 810 megawatts of projects in development in Maryland, New York, Rhode Island, and Connecticut, as I think you've heard a couple of times. I was not part of negotiating that transaction nor of the due diligence, so I know as much as I knew about those assets from public sources last Wednesday. I met my new colleagues in Providence last night for the first time, but I'm not really going to be able to speak to anything about these legacy deepwater assets, although I have some sense of the transaction itself, if there are questions about that. And what I wanted to do was go through. It's been very good to hear about the individual states, from Noah, from Amber, and from Scott. I thought I would give a brief overview, sort of taking a more holistic national picture of offshore wind right now, and then maybe dive into one particular issue that probably hasn't been discussed much in Energy Bar Association meetings in the past, but is an interesting little legal issue for offshore wind. This is a current map, and I think this one actually is current, a current map of the existing targets and markets for offshore wind in the United States. And as you can see, relying largely on renewable portfolio standards, but now on offshore wind specific targets, goals, and mandates, we now are looking at a 12 gigawatt market on the east coast of the United States. And as a personal aside, I joined Ørsted almost 3 years ago, and I moved my family from here in New York up to Boston, which isn't the moon, unless you ask my wife. And at that time, Massachusetts hadn't actually enacted its energy bill that was going to mandate a procurement of 1.6 gigawatts. So in the time since then, to see us go from 0 to 12 gigawatts of targets is, it staggers me every time. And, you know, it's only the start. I know that there are other states on the East Coast that may establish targets. Targets that the individual states now have may grow. Of course, there's the West Coast, if issues regarding floating technology can be properly addressed. So, again, we've heard about some of the individual states, and this is trying to provide a picture of where we are as an industry. This is an industry that is growing at an incredibly rapid pace, and it's been very exciting, if a little bit hectic, to be a part of it, at least at the outset. I'm going to run through very quickly some of these individual procurements, probably pretty quickly because Noah and Amber and Scott have already addressed them, but I'll just make a couple of observations going down the East Coast. Massachusetts was, I think, the first to establish a target. New Jersey, I know, had a legislative framework for offshore wind several years ago that Governor Christie put on ice for a while. But I think Massachusetts might have had the first statutory target in that 2017 energy bill. Vineyard Wind obviously was the winner in the first procurement. The next procurement will have to start no later than, I think, June of next year. And Massachusetts has now doubled down, literally. They have increased their 1.6 gigawatt goal to a 3.2 gigawatt one, although there's some discretion as to whether they need to take that additional step. And I think, like some of the other states, they have not yet looked at. Massachusetts' RFP did require bidders to propose what they called an expandable transmission solution, which is not quite the kind of shared transmission infrastructure that I think companies like Anbaric are proposing, but they did they gave a try to seeing whether they could make that part of their first solicitation. It didn't work out. I think the language that they've added to the statute, I think, contemplates that for the next go-around, they will take more of a look at shared transmission. Rhode Island, which, as my new colleagues reminded me last night, is the home of offshore wind in the United States, so something to forget, has obviously the first operational wind farm in the United States, the 30-megawatt Block Island project, the 400-megawatt award to the Revolution Wind project that Amber's mentioned. There's currently a clean energy procurement underway in which offshore wind may bid. Deepwater Wind and Vineyard Wind both submitted bids. Ørsted did not. I've indicated it's a 400-megawatt RFP. However, I think for an individual project, there's a limit of 200 megawatts. And I think we're expecting to, I suppose, see the awards of that next spring. Connecticut, probably not much I need to say here, except to be aware that I'm not sure whether Ørsted and Deepwater Wind and Vineyard Wind all submitted bids in the so-called zero carbon RFP, this large RFP that I think serves as part of purpose to address nuclear power in Connecticut, but also I think resulted in 100 plus bids.
I don't mean to interrupt your presentation. If
Yes.
we could not talk about that, because I am...
Sure, you got it.
Thank you, sorry.
Moving on. Very quickly. New York, again, very little for me to say here, but yeah, the second appearance of Noah's map. And now one that hasn't been talked about yet, but which is actually next in line here in the United States, is New Jersey, which, as I mentioned before, was the first state to, I think, implement a statutory framework for offshore wind, and now has established, I think, for an individual state, the most ambitious statutory mandate of 3.5 gigawatts by 2030. We have a procurement that is, well, bids are due on December 28th in the current sort of OREC procurement. And there the applications can be for bids of up to 1,100 megawatts. So again, pretty ambitious in terms of scale. There's going to be a 180-day evaluation timeline. I'm not all that familiar with how the evaluation process is going to work. There was a technical conference last week that I did not attend for other reasons. But I think this is really going to be a big undertaking by New Jersey. And just a couple of detailed points here. As I mentioned, the overall size of the procurement is 1,100 megawatts. They're accepting bids of anywhere from 300 to 1,100, with a required 400 megawatt bid so that there can be an evaluation of the benefits of selecting multiple winners rather than one large-scale project. The incentive regime here is also like New York and OREC, but it is quite different, I would say, in its calculation. The OREC here is sort of an all-in revenue requirement, with developers who are awarded it required to turn over energy and capacity market revenues, if any, although they're not required to participate in those markets, to New Jersey ratepayers. And in the evaluation process, there is a heavy focus, much I think is in New York, on whether there are going to be net economic benefits to the state, with a particular focus on the state's manufacturing economy. So applicants are required to make a forecast of their own costs and benefits for New Jersey, the economic commitments they're going to make. There's a possibility to make those commitments. I think I don't know if you're directed or suggested to come up with a way to make those binding the way New York has, but it's clearly an area of focus for all of the states. Also an out-of-date slide. Now that I hear that these New York lease areas have been maybe a little bit more narrowly defined, but these are shots of a couple of the upcoming BOEM lease auctions, which will certainly add to the number of competitors here. If one looks at the BOEM order or final sale notice for this Massachusetts lease auction on the left, there are quite a few large multinational energy companies that seem to be in the mix, and a lot of other names that are mysterious and could be who knows who. So clearly a lot of interest to go along with those ambitious targets that the states are presenting. This, I think, again, unfortunately, slightly outdated, but this was a projection of the market growth that we're seeing. I mean, it's really on the fast track, and it's a fascinating industry to be a part of here in the U.S. at the moment. This is a slide for which I really have to credit BOEM. I think it's a really nice image here. I think you have here some indication of our U.S. coastal load centers, and in particular on the East Coast, the location of the areas where BOEM is either has leases or is exploring leasing. It really shows the way that, I refer to this as a new industry, but remember that Ørsted started with offshore wind 28 years ago. And so what we have is a new technology in the U.S., but a proven utility-scale renewable resource around the world that, for various reasons, accidents of history, hasn't yet taken off in the United States. So I think this slide does a nice job of sort of really illustrating why it's a good fit. And we could get into things about wind curves and how they match up with the duck curve and all of that, but this is probably a more pleasing image. So having said that, there are a lot of different state regimes here. There are differences between the way the states are approaching this. For Ørsted as a European company, it's been a learning experience to learn about cooperative federalism, to know that each state can be operating differently. There are different rules, but fundamentally that's not that different from what they face in Europe. We have wind farms in the UK, certainly in Denmark, in Germany, in the Netherlands, now in Taiwan even. So we're used to dealing with different flavors of regulatory regime. But there are some things that are really fundamentally different. And the coastwise laws in the United States are an example of just that. That are, I would say, not an obstacle or a problem for offshore wind development, but a new consideration for an industry that has been based in Europe exclusively until very recently. And again, the coastwise laws, I doubt, are discussed in Energy Bar Association events much, although I did in my prior job, which was a largely Natural Gas Act practice. We had a client who asked about the Jones Act. So probably the only reason I have this job is that when my current boss asked me about the Jones Act, I happened to know what it was. But very briefly, the Jones Act has been used as shorthand for a suite of 4 so-called coastwise laws that are designed to, I think, protect the U.S. Merchant maritime industry and shipbuilding industry, with a particular focus on doing that for interests of national defense. I think I read that the first coastwise law was passed by the first U.S. Congress in 1789, so it's nothing new. The text of the statute as we now have it dates to 1920. Seems doubtful that it will change much. At a very high level, the Jones Act, strictly speaking, prohibits non-U.S. vessels from carrying merchandise between 2 U.S. points. So, for example, if you want to take a cargo of oranges from Miami to New York, you're going to have to use some kind of U.S. vessel. And this has implications for the offshore wind industry because so many of the large purpose-built installation vessels that that industry relies on are not U.S. flagged. And so you have to figure out exactly how you need to tailor your operations towards the Jones Act. Although there is a body of Coast Guard and Customs and Border Patrol regulations, I think that the Jones Act's requirements are really elaborated mostly through letter rulings from Customs and Border Patrol. And by the way, they maintain a really good online database. It's better than Westlaw, not in terms of user interface, but in terms of records. It's the cross rulings database. So if you ever want to dive into one of these, it's a good one. There is a misconception in the U.S., or there has been a misconception that say the Block Island Wind Farm obtained waivers from the Jones Act to get built. Waivers are only available, strictly speaking, for national defense reasons, and I understand that they're probably very hard to get, as exemplified by how long it took to get a national defense waiver of the Jones Act to get relief supplies to Puerto Rico after the hurricanes, and even then it was a 10-day waiver. So unless it's in the interest of national defense, it's not going to happen. Again, what you have are letter rulings that say what you're doing doesn't implicate the Jones Act. So it's not a waiver, it's just an acknowledgement that you are not running into any of these prohibitions. There was a thought that the current administration would perhaps tighten these regulations. These rules. Hasn't happened yet. There was a proposal, I think, shortly into the new administration to make certain offshore oil and gas activities subject to the Jones Act that hadn't been before, but that was eventually withdrawn. So maybe the legal requirements will get tighter. They certainly are not going to get any looser, I don't think. And very briefly here, I said you can't take the oranges from Miami to New York unless you have a coastwise, a U.S. vessel. There are 3 elements to that. Owned by U.S. citizens, which is probably pretty workable. U.S. flag, also pretty workable. It's the standard about being a U.S. built vessel that I wanted to point out, where, as you can see, very little, if you have a vessel that has any other work done on it, very little of it can be done in a foreign shipyard. So this is a quite strict definition. Getting to the items that are covered by the Jones Act. And by the way, I have pictures of a few offshore wind installation vessels because I figured that'd be more interesting than what I'm saying. Unfortunately, I discovered that this might actually be an artist's rendering. This one might not exist yet, but it looks very impressive. Merchandise subject to the Jones Act is essentially anything that's loaded in the United States other than equipment that is, as you can see, necessarily appropriate for navigation and functioning. To give you an example of where that line is drawn for offshore wind survey vessels doing either the geotechnical or geophysical examinations are not subject to the Jones Act, and even the samples that they take, the core samples that they pull up, are considered not to be merchandise, rather to be connected to the operations of this scientific research vessel. Passengers under this, I'm referring to the Jones Act generically. It's the Jones Act on merchandise, this Passenger and Vessel Something Act on passengers, the Dredging Act, and the Towing Act are the ones specifically. anybody who is not essential to the operations or is not connected to the operation of a vessel is a passenger and similarly can't be transported from point to point. There's something about cruise ships having to visit some foreign port. I've never been on a cruise ship, but I don't know. But I think that might also be related to Jones Act considerations. No cruise aficionado. And I think it goes from like you have to spend a little bit of time at some foreign port, something like that. For offshore wind, although the crew of an installation vessel may be appropriately considered passengers, not to be passengers, other, say, workers that are being taken from location to location would be. And so we do in the U.S. have at least 2 purpose-built U.S. crew transfer vessels. That's not one of them. I think that's a European one. Because the sense was that those are, I think, relatively easy to construct, probably makes more sense to build them domestically anyway, and workers may be considered passengers when they're going between these locations. But also, sort of getting into the weeds further, the workers aboard the installation vessels may or may not be considered passengers depending on their function. And here's the sort of the reason that this is relevant to offshore wind is that I talked about taking oranges from Miami to New York, but it's not port to port, it is point to point. And point can be, I mean, I've been told that if your ship leaves one dock in a particular harbor, goes out for the day, and then comes back to another dock that's a couple of 100 feet away, you've gone from point to point. So it's pretty strictly construed. It applies, the Jones Act does apply directly to the territorial seas, so going out up to 3 nautical miles from shore. And Customs has ruled that it also applies to any areas that are subject to jurisdiction under Section 4 of the Outer Continental Shelf Lands Act, which, as Josh will probably mention, is the statute under which BOEM operates. So it's not, if say an offshore oil and gas vessel goes to a certain location on the Outer Continental Shelf and jacks up the way that offshore wind vessel is doing, it would presumably become a point. And that would limit its ability to transfer merchandise that it had loaded, say, at the dock in Houston to take it out to a point on the Outer Continental Shelf a few miles away to install in the ocean. That would then be merchandise being transported from point to point. So, having said that, what are the implications here? What do offshore wind developers need to do? Well, I mean, you need to figure out what the Jones Act does or does not allow you to do. Some developers, I mean, there is a letter ruling that the Block Island Wind Farm obtained. I don't know any of the background for why that was done. Certainly, if you're taking some sort of novel approach, you might want to approach Customs and Border Patrol and get a ruling, or your lenders might insist on it. The other thing that we have, that Ørsted has discussed in some of our prior bids was the idea of U.S.-built offshore wind installation vessels. To sort of really facilitate and remove any uncertainty about what may or may not be possible and facilitate this pipeline. That's, a large capital investment, a significant timeline. I'm not sure where those discussions have gone for us or anybody else. It may also be something that turbine manufacturers might be interested in, especially if they were considering moving operations to the United States or maybe other kinds of offshore wind manufacturing. But it's, as I said, not a problem, but a consideration, and for us as a European company, a new consideration. And just because I wanted a picture of one of these cable-laying vessels, because I think they're pretty cool. One of these coastwise laws is the Dredging Act. In theory, if you're installing a submarine cable, you might be engaging in dredging that requires a qualified vessel. That depends pretty technically on the nature of the technology you're using and the scope of the activities. And I think that's it.
Okay.
Well, I'm told we have now capability to connect with you states, so hopefully we can.
I personally don't.
Oh, yeah.
All
Thank
right.
you. I think we can go back to Josh now. Thank you.
Okay. Josh, can you hear us? And
I can hear you. Can you hear me?
yep, we can.
All right.
All right. Let's. Where am I? Where am I? Oh.
So my name is Josh Kaplowitz. I'm an attorney advisor with the Office of the Solicitor at Department of Interior, and my client is the Bureau of Ocean Energy Management's Offshore Renewable Program. I should, I guess, start with the same disclaimer that Amber did, that these slides are informational, and you shouldn't take anything that I say as an opinion as the policy of the United States. That all being said, I thought it would be good to first start by putting the federal process in context of what we've heard so far. So the federal permitting process is separate from all these state RFPs. Legally distinct. We do a lot of consultation with the state on every level. The their environmental divisions, their coastal resource management divisions, and we've started commenting, as Noah knows, we started submitting comments on the RFPs on the issues that implicate our leasing process and program. But it is a distinct process. We do, the places where they interact are, typically a state RFP would have as a precondition for applying, holding a BOEM lease, which makes sense, as we'll talk about shortly. These leases are leased competitively, so it wouldn't, you're not guaranteed to get one unless you sort of purchase one from an existing lessee. It's sort of to the highest bidder in these auctions, so it wouldn't make a whole lot of sense to issue an RFP to a company that may never actually end up acquiring a lease. But that said, just because you have a power purchase agreement through a state does not guarantee you the federal approvals. And often these power purchase agreements are contingent on getting all your federal, state, and local approvals. So they are distinct processes. But that said, they're important, and they do often shape what to varying extents, what the project ends up looking like, and certainly where it's located on the Outer Continental Shelf. So just getting back to the agenda, I'll talk about our statutory authority, our regulatory authority, and then we'll take a very short flight through our sort of leasing and permitting process. And this is a picture of the Vineyard Wind project that Scott has talked about. This is the first permit that we received, sort of under the competitive process. We'll sort of set Cape Wind aside. That was actually sort of grandfathered into the program. But that's what we're reviewing right now. And the next slide. So let's start with our statutory authority. It derives from the Outer Continental Shelf Lands Act, OXLA, and so geographically we lease. We're like the landlord of the Outer Continental Shelf, and that starts typically 3 miles offshore. There are some parts of the Gulf where it's longer, where it's further offshore, but obviously we're talking here about the Northeast, so it's 3 miles. So if you want to site a wind farm within 3 miles, there are some federal approvals. You'll need to get Army Corps permit, for example, but by and large you'll be dealing with the state on the siting of that. And so there are a couple. Obviously, the Block Island project that's been mentioned is in state waters. There's one or two others. The Great Lakes we don't have jurisdiction over, but roughly 95% of the action is where we are. Going forward on the Outer Continental Shelf. Next slide. So our statutory authority is kind of a funny thing. It was based on a portion of the Energy Policy Act of 2005. That sort of tacked a subsection onto the end of one of the provisions of OXLA, Section 8P in the citations there. There are other parts of OXLA. So most of OXLA has to do with oil and gas leasing, Deepwater Horizon, all the everything, all the drilling was how OXLA was the primary purpose of OXLA when it was originally passed. And so they tacked this section on. There are other parts of OXLA that do that we read as applying to the wind, the offshore renewable program. If it's not specific, if there's not language specific to oil and gas, civil penalties, sort of certain antitrust reviews of lease sales. But interestingly enough, there is no legislative history to Section 8P, which can be good or bad, depending on how you look at it. 8P1C, this is the provision that sort of gives us the authority to grant leases. Easements are right-of-ways. Rights-of-way are more, talking about sort of cable corridors. The leases are the sort of blocks that the wind farms are typically sited in. And the language is, if those activities produce or support production, transportation, or transmission of energy from sources other than oil and gas. So interestingly, our statutory authority does not actually mention renewable energy or, let alone wind energy. But that's what we have. And so it's sort of a catch-all of like energy. We have jurisdiction over energy production on the Outer Continental Shelf that sort of isn't otherwise covered by other parts of the statute. Next slide. So another important aspect of our statutory authority is the fact that we have to lease competitively. And so this really drives the sort of planning and auction process. I mentioned before, we hold auctions. And so in order to acquire a lease, again, unless you want to sort of purchase it from an existing lessee, you have to go through that process and bid, and we have a sort of a Federal Register determination. We put it out for a determination of typically of whether there's competitive interest, and the only way we can lease it non-competitively is if no one other than one person or one company is interested. Next slide. So this provision, the text is a little small, but 8P14 sort of sets forth all of the criteria under which we review activities on our leases. And as you'll see, I won't belabor it too much, but it's awfully broad. And so, again, good and bad, it gives us some flexibility. It's a matter of time before courts do weigh in and sort of provide some interpretation, but we view this as a sort of a balancing test of other uses versus the sort of commercial needs of the developer who's proposing the activity. But that really is the sort of core challenge that we have, is to sort of permit proposals while considering the many other uses of the Outer Continental Shelf. Next slide. So we promulgated regulations back in 2009. There's the citation. They were originally modeled out on the oil and gas, offshore oil and gas regulations. We have a rulemaking underway to sort of clean up some of the issues with our regulations that sort of have cropped up over time. In 2009, there was not an industry in the United States. There were obviously turbines being constructed in Europe, but we've learned some lessons as we've sort of implemented the regulations. By and large, they've functioned reasonably well, all things considered. But we are working on a rulemaking to make some tweaks. Next slide. So this slide sort of shows an overview of our process. Noah had challenged me, I guess, to talk a little bit about New York. So maybe I'll just use New York as an example of sort of how we get pass through this process. We start out we have these intergovernmental task forces where we work with state governments, other federal agencies, local governments, tribes, and we kind of sit down with them and try to figure out what are the areas that we all think would be best, offshore a certain state to lease for potential development. So the map that Noah put up on page 31 of his slides is sort of, that's the first stage in the process. We sort of put out a broad area, and then we sort of funnel it down. So we have received comments on the sort of larger areas that we put out in the New York Bight. And based on those comments, we just very recently put out a draft concept of where within there we would like to lease, or we're considering leasing. So we take those areas, and those are the areas that we and in doing that winnowing, we consider commercial considerations. We consider environmental factors. Where's there a lot of fishing. Where are the navigation channels? We sort of mash a lot of different factors together and sort of come up with what we think are the best / least conflicted areas. and then we put those out for an environmental analysis. We don't at that stage analyze what a full wind farm build out would look like, and that's an important point, and actually one that was recently litigated. In a later slide, you'll see that there was a case called Fishery Survival Fund v. Zinke, in which fisheries groups challenged us and said, you can't issue leases unless you've analyzed what that lease would look like full of wind turbines. And our position is, and which was upheld by the court, was that our lease actually doesn't allow for construction. It allows you the sort of exclusive right to submit a plan. So it gives you the assurance that you can spend $10 million or however much it takes to survey your area, generate the data that we need to that the developer needs to submit a permit application. But then we have a clean cut at whether your project that you propose can be approved, disapproved, or approved with modifications. So because the lease doesn't give you any rights to build, we don't need to we haven't committed the resources, and we don't need to do a full environmental analysis of what wind turbines, what the impacts would be of the area being full of wind turbines. And that actually makes some policy sense better because this is an interesting industry. The permitting timelines are very long. It takes up to 10 years between sort of first identifying potential areas to approving a project, and in that time frame, technology is developed fairly quickly. A good example is the Cape Wind project proposed 3.6 megawatt turbines. Now, developers looking forward are talking about turbines as large as 15 megawatts. So you're talking about almost a fourfold, or more than a fourfold increase in the capacity of these turbines with larger sizes, and that really makes a difference in terms of how these wind farms are laid out. So to analyze, today's technology when you haven't even issued a lease yet, is awfully speculative, and inevitably, in our estimation, would result in needing to redo your environmental analysis. So that's the approach we've taken, and we're fortunate, at least thus far, that courts seem to agree with us. So I've thrown a lot. I've sort of gotten out way ahead of my slides, but yeah, I mean, I guess go to the next slide, and we'll talk sort of through other. Yeah, so this describes a lot of what I was talking about in terms of the initial planning process. And what you'll see here is that there's a large number of consultations we have to do. It's not just the BOEM approval under the Outer Continental Shelf Lands Act. We obviously have to go through the National Environmental Policy Act review, which doesn't dictate a specific result, but it's a process that we have to go through, and not only have to go through, but need to go through in order to fully flesh out what the potential impacts are and how we might mitigate them. Endangered Species Act comes into play. You have a number of species, but the most important being the North Atlantic right whale is the one that environmental groups are really focusing on, and particularly the impacts of the noise impacts of pile driving. But at the earliest stage, at the lease issuance stage, we're not worried about that yet, because all we're analyzing is the surveys and also what we call the sort of site assessment activities, where you deploy typically a buoy to measure wind resource. But lots of consultation, states, other federal governments. Next slide.
Okay. Yeah, I think you're back.
Oh,
Okay.
can you hear me?
Yeah, we lost you just for a second, but you're back.
Okay. I was worried that I was boring everyone. Next slide. Here we talk about the surveys that companies do. We don't actually permit these, but we do have lease terms that govern ways to do it to typically protect marine mammals. Next slide. Site assessment. This is these buoys. They used to be, the industry standard used to be Met towers, which were pile driven into the seabed and were up to as tall as the hub height for the potential future wind turbine. Now they have technologies where the buoys essentially shoot a laser up into the sky and can measure the wind speed at hub height without having to pile drive into the seabed. So that's where the industry is gravitating. Environmental impacts of those are much less, so we're actually working on looking at ways to streamline the permitting of those buoys. Next slide. The construction and operation plan, or the COP, is the main event, and this is where we do the most rigorous NYPA analysis, a full-scale environmental impact statement with consultations, Endangered Species Act, Magnuson-Stevens, Essential Fish Habitat, the National Historic Preservation Act. CZMA, the Coastal Zone Management Act, is a mechanism by which states can weigh in and determine whether the project is consistent with their sort of coastal priorities, coastal resource priorities. And then we do informal coordination with Department of Defense on military issues. BSEE, the Bureau of Safety and Environmental Enforcement, is sort of our BOEM's sister agency, and they primarily focus on safety. They don't actually have legal authority at the moment, but that is maybe coming down the pike soon. Right now, BOEM is the sort of one-stop shop for federal offshore wind permitting. And there are a number of other permits that kind of get thrown into the mix. Now, it looks sort of daunting, and it can be, but this administration is working on some federal streamlining, which is in the next slide. There are a couple of initiatives going on to try to get BOEM, the lead agency on these major infrastructure projects, to sort of coordinate and herd cats on all of these different authorizations and consultations. So the FAST Act was passed in November 2015. That's a congressional mandate to streamline the permitting process. The executive order 13807 is an administration initiative. There are a lot of similarities between the two, arguably some duplication, but if you go to the next slide, you can have a little more information about that. So the idea with these is to get the agencies talking to each other and coordinating. So it sets a timeline. Both of these set a timeline for permitting review, which is, I think, helpful to provide security and de-risk these projects, because in theory the developers will know when they will get a permitting decision. And it sets up a timetable that all the relevant agencies agree to. There's a lead agency, which is us, and then everyone else is either a cooperating or permitting agency. There are points of concurrence along the process where everyone agrees to sort of what the NYPA alternatives are that are analyzed, what the preferred alternative is. And then if agencies can't agree, there are sort of appeal mechanisms, which is helpful because in the past you've had problems where certain agencies have managed to sort of drag their feet and hold up the permitting process, and not naming names. And then for Fast 41, the real differences there are you get these legal protections if you enter it's voluntary, and there's a public permitting dashboard so you can see where each permit is in the process. They're working on potentially having a applicant fee, and there are some legal protections, a shorter statute of limitations. I guess we'll find out what the merits of those are. Going from 6 years to 2 years, I don't know how much that really gives you. If someone wants to challenge your project, they're gonna file a challenge probably within 2 years. Next slide. Another unique aspect of our permitting is something that we've developed pretty recently and actually borrowed from Europe, which is where a lot of the best ideas of that offshore wind come from. It's called the project design envelope. And the idea is that when we get a proposal, we don't get the sort of exact 100%, design, with every single detail about where every single turbine is going to be and what exact technology is going to be used. We get a range, what we call a reasonable range of parameters. And this is helpful because the permitting process is long. It's an iterative process. There's a lot of stakeholder engagement even after a permit is submitted. and it preserves the flexibility so that if there's a mitigation measure that needs to be imposed, or circumstances change, or a stakeholder comes out of the woodwork in the comment period, you've built yourself some flexibility, so you don't need to go back and redo the entire permitting process, because you've at the outset decided to look at a range. And the way we square this with NYPA is we analyze the maximum case scenario. We analyze the most impactful parameter for each resource that we analyze. And so an example I would give is a developer could come in and say, we think we're going to use one of two different types of foundations: a monopile, which is sort of one tube that's pile driven right into the seabed, or gravity based, which is like a concrete shell that gets filled with sand and other ballast and sort of sits on the seabed and is anchored in place by gravity. And so those are two technologies that are in commercial use. And so what we would do is say, okay, we'll consider permitting both, but the impacts are going to, the maximum impacts are going to look different for different resources. So for marine mammals, where sound, noise is the biggest factor, using all monopiles would be the biggest impact. Whereas for seabed habitat disturbance, the gravity base, which is wider, might be the one that's used. And so we would look at each parameter differently for different scenarios, for different resources. In theory, at least, this preserves flexibility and hopefully minimizes delays by not having us have to restart the process. And it's worked reasonably well so far. Next slide. This is I'm not going to belabor this too long. It sort of gives the process for how once we get a COP, the steps that we take until we get to a decision on whether to approve it. The important thing on the bottom is that we do have the authority to modify the proposal through a NYPA alternative, or through mitigation measures. So that's obviously an iterative process, and we take a lot of things into account, but we do have the ability to do that. Next. All right, so you have your COP approval. You're not done yet. We have a stage at which you have to submit a facility design report and a facility installation report. I guess it's a fabrication and installation report, I should say. Gotta correct that. These are reports where we have 60 days to review it, and we can object, and then you have to go back and correct it. But the important thing here is that your reports have been third-party verified by a certified verification agent, and that's a major aspect of the process. And finding the right CVA is an important thing for developers to get right at the start, because you want your project to not fall over and actually generate electricity into the grid. And you have to provide financial assurance. This is something that sometimes gets forgotten, but we do an you're obligated to clear the seabed at the end of your lease, and you can request a lease extension to continue the life of your project. We look at those. We'll look at those when we get those requests, but you need to provide us with financial assurance that if you, the developer, go bankrupt sometime in the operating term and can't offload your project onto a solvent company, that we have the financial assurance to then pay for the decommissioning ourselves. And so we do an estimate on the front end of how much that is. And then for decommissioning, you submit your plan 2 years before the expiration of the lease, and then you have 2 years to clear the seabed. Next slide. We've seen various iterations of this map before. I don't need to belabor it, but that is the federal process, and happy to take questions with everyone else.
Mic on. Thank you, Josh. So we have 12 minutes for questions or so, and we've covered a lot of material. I have a few questions, but I'm going to hold those and make time for others to ask their questions first, so we can come back around to mine if there's time, and some inter-panel discussion if there's time. But let's start in the room here in New York. It's been alluded to a few times in disclaimers, and we've gotten too close to the edge of some ex parte stuff, but we'll ask some questions about a current RFP. Use good judgment about that, and don't wander too close to the edge. There is no fence or guardrail, so tread carefully. So with that, I think there was a question on Noah's presentation earlier. If you wanted to start with that.
I was curious about the PLA because I worked on some low-income housing projects that had labor requirements, and to do the project in budget and in compliance with the PLA, they used modular construction and assembled the whole thing in central Pennsylvania at the prevailing rate there, and then just trucked it to New Jersey where the project was built. And I don't know if you can talk about this with the ground rules you gave us, but thinking about the fact that we're actually bringing stuff in by ship, that opens up a huge area where you could be doing the construction, and I was wondering how people were thinking about that.
Well, this is a multifaceted, this is like a three-dimensional question, right? There are realities with respect to the state of the offshore wind industry, which I'm sure Charlie or others can talk about even better than I. I think it's a reality that some of the blades are probably going to be manufactured in Europe and brought over. There will be other pieces of it that will be manufactured here, and that's all going to evolve over time. There are port facilities in different places now. Those port facilities, new ones will be built, and that's all going to evolve. So the prevailing wage and the project labor agreement are one piece of the state's effort to ensure that there's a benefit to New York, but there are additional economic benefit, requirements / requests. The background on the speaker is really bad.
Let me in DC, before we get to questions there, could you mute that? Thanks.
So there are a number of additional economic benefits points that developers can get based on fabrication and other activity here in the state. So the idea is that a combination of those will lead to the most activity here in New York as is commercially feasible for this phase one.
And I would just add that the challenge for developers is that there are multiple states with procurements ongoing or forthcoming, and they would all like or insist upon a level of economic development. So I think there are certain mechanisms to ensure that developers have every incentive to engage in those activities in those particular states that they're serving. But yeah, there are some constraints just due to the supply chain about what can be done at this stage of the industry.
Okay. Yes.
Hi, Charlie Carroll with DLA Piper. I'm intrigued by the decision to punt transmission and to leave each individual developer to make its own decisions and arrangements for that. It seems to me to increase the environmental impacts of offshore wind and raise the costs of it, inevitably. And I just wondered, as you look at the map, and I consider the right whale and other endangered species, I don't understand that.
Yeah. Well, I mean, I can give you the rationale that's in our order. I think Charlie mentioned the effort in the Massachusetts RFP to encourage developers to, bid in sort of an extended transmission infrastructure, which pretty much fell flat. Without an ecosystem of wind energy areas out there, you're sort of building a transmission structure without a lot of, facilities to plug into it right now. And so I think, in fact, on the front end, the cost would be significantly higher for these facilities if they were bidding an integrated transmission structure in at the same time as as the project itself. Over time, it's going to make more sense. I mean, there are different lines on the graph, and what we're trying to do is get to the right spot where it makes sense.
So that's a great question. That's I wanted to ask that. So I'll take just a little moderator's prerogative and just
fight back.
expand on that. So I mean, your notion is what we've seen in Europe, right? I mean, Germany, you build some.
It's happened in different ways in Europe. I mean,
Right.
I think NYPA actually.
My notion is that if you want this to succeed at large, you're talking about 2030, right?
Sure.
So you should. It's 2019, right? So you should have a view as to where you want this to happen, and what the most rational. Like, we don't have transmission lines crisscrossing the terrestrial United States because it's wasteful and destructive. So what's the difference? Is my question.
So it'll be developed in phase 2, which happens this year.
I think, Noah, you said that one of the objectives was how do we get these things up and running as fast as you can. Amber mentioned that you're sort of piggybacking off retirements right now. There's open substations. Run the radio line in. But I think, I would agree with you. I've been doing transmission planning for years and years now. And it is one of those things where, as I look at like New York and New England, I see a perfect Order 1000 public policy plan. It's not a developer cost at all. There's federally regional allocation for those types of projects. And 3 New England states and New York could share the cost of that. So it'll be interesting to see whether we start to think of offshore wind transmission, like terrestrial transmission, say, let's all plan something together, but to Noah's point, have enough information about where it goes and what it does at that point. So that, the same thing has occurred to me.
So,
if we could just not type in that we're picking up the typing in the DC office. Sorry.
I think Josh.
sorry, we just unmuted. I was just going to weigh in a little bit on the.
Okay.
Josh.
Sorry, on the environmental impacts. I mean, obviously, BOEM's kind of following where the market goes in large respect. But as far as environmental impacts, I mean, one thing I would say is, and developers correct me if I'm wrong, but I think once you have a transmission card, or like if one developer with a lease, they get one thing I didn't mention is you get an easement with your lease. So you have, at the time of COP approval, you get a transit card to build your export cable to shore, or at least to the 3 mile line, and then you get state authorizations for the last 3 miles. But it is possible to cite, just because we have an easement doesn't mean that some other developer can't, if it's technically feasible, can't lay a cable next to it. So there are ways in the future and I'm not sort of opining one way or the other on the merits of regional transmission, but I think as long as it's technically feasible, I think that BOEM is okay with citing transmission in close proximity to each other, and in fact would certainly be looking at the ways that doing it that way would mitigate environmental impacts, to the seabed and fisheries and whales.
One more question
Theodore.
Oh,
yeah. This is Scott. This is Scott Mahoney Providence. Maybe if I can just weigh in on this, because we looked at this and looked at expandable transmission in our Massachusetts submission. We have experience with expandable transmission through our Scottish Power affiliate, who has offshore projects in the UK, and where they have used sort of an expandable transmission model. We think that the sort of the generator lead model here works really well, especially when you're talking about sizable developments. And in particular, it gives control to the developer. And here we're timing and project financing and being able to control, everything that you need to make the project, come online, when it has to come online, is so important that to try to allocate that to someone else and then deal with the risk associated with that, would be very difficult. Maybe as these projects move further out, that there's more of a gathering system or something like that's going to make economic and project sense. But I think for us, this is a very good model.
I remember that with the was it the Atlantic Wind project, they were going to build a backbone along the coast, and the idea was that, and I'd be curious to whether the developers think there's any benefit to this, because one thing they were talking about is being able to move power from one area to another, or possibly for resilience issues if there was a part of the grid went down in some areas. So I don't know if that's something that's important to people, or if they don't think it's valuable, or if it matters at all, or if it makes it too hard. I mean, is all the power just moving into the coast? Is that really what the main market is, or does it matter to have that other flexibility?
I mean, my personal view is that with a more mature industry, there may be an added benefit to being able also to add that flexibility with that kind of solution. In the current system we have, where you get your lease from BOEM, you bid in an auction from a state. I mean, you saw Noah's map. There are projects, I don't know how many miles apart, that could bid into New York. It's very challenging ex ante to come up, for any state to come up with some solution on how a shared transmission facility should play into their auction. Maybe down the line, when there are more lease areas, where when it's clear where the development is happening, where there'll be expansion. But if we look at Germany, for example, you bid in an auction, they say, okay, build a wind farm of this size right there, and we'll bring you the grid there. That's just not what is happening here yet because of the federalist aspect to it. It may be over time that changes, but it's whatever the virtues, and I'm not discounting them. It seems that the states that have considered it so far have felt that it's a little bit too early. So.
Okay, one more question in New York.
It's more about just a response to you. We think that the transmission, the coordinated transmission, as Noah noted for phase 2, is appropriate, but the public policy transmission process, the issues with respect to that are timing and expediency. That process has been a belabored process in New York and other places as well, and syncing up completing a transmission project with the generation being completed so that the timing works would be difficult under that process.
Sure. Can I add on to that too? I know the New England states have been very concerned in Order 1000 in terms of the lack of cost discipline. I know Scott referenced 83C has built-in cost controls, and that is lacking at the federal level. I know we've weighed in at FERC on that. We may see some guidance, but for now I think in New England, there's been some hesitance until there's some ability to sort of limit any cost escalation.
Interesting. All right, and in DC, I can't see you, but hopefully we can hear you. Is there any questions there? I will take that low hum as no. All right, everybody, join me in thanking our panelists. This has been really, really good.
I just want to make sure that everyone knows that we're having a reception immediately. Can you hear me?
Yes, we hear you.
Oh, okay. There's a reception. Everyone's welcome to a reception in both locations. And Deal is happy that everyone was able to attend, and thank you very much.
Thank you.